Madam President, I'm expecting Senator Lee from from Utah to come to the floor momentarily to resume debate over an issue which was raised yesterday and we suspended to move to a vote that had been previously scheduled. But since this this issue that we are discussing is of such importance to so many individuals in our country today, and many of them are following this debate carefully and closely, I wanted to make sure that we return to it today to at least consider one aspect of the debate. Yesterday, when I made a unanimous consent request, Senator Lee said he'd not had time to look at my proposal. That's why I waited until today to come back so that he would have that opportunity. Yesterday, I came to the floor to speak about the plight of immigrant workers who were suffering because of a serious problem in our immigration system known as the green card backlog. Many of these immigrants are essential workers who are helping to lead the fight against COVID-19. But the green card backlog puts them and their families at risk of losing their immigration status and being subject to deportation. Under the current law, there are clearly not enough immigrant visas, also known as green cards, available each year. The numbers that we have established in 1990 are still applicable today, though our national economy has doubled since then. We are still talking about 140,000 employment visas each year. These so-called green cards have resulted in many people waiting for long periods of time, literally for years, for the opportunity to become legal permanent residents, and securing one of the green cards. While they are waiting, their families are at risk. These backlogs are particularly difficult on children because as they wait, the children, of course, advance in age, and when they reach age 21, regardless of whether the spouse or parent, rather, has a green card, they are subject to deportation. I have met with these families and I've talked with them. It's a heartbreaking situation, and the unanimous consent request, which I will make today, addresses the plight of those children directly. Senator Lee objected to it yesterday, but said he had not had a chance to look at it. I hope he'll reconsider when I make the same request today. These children who face what we call aging out at age 21 would be protected by this unanimous consent request, which I'm making. In addition to the green card backlog, it's clear that there is a solution to this issue, which I'm afraid we are not going to be able to achieve. It's to increase the number of green cards available each year in this country. These immigrant workers who are seeking green cards are already in the United States working legally. This is not a question in increasing the number of green cards of bringing in new immigrants to compete with American workers. These workers are already here. It's about whether immigrant workers will continue to be able to work on temporary visas where they have to depend on their employer for their immigration status and their future is uncertain. I introduced legislation known as the Relief Act. My co-sponsors are Senator Patrick Leahy of Vermont, Senator Mazie Hirono of Hawaii. The Relief Act would increase the number of green cards to clear the backlog for all immigrants waiting in line for green cards within 5 years. Eliminate the backlog for green cards within 5 years. This Relief Act would keep immigrant families together by treating children and spouses of green card holders as immediate relatives, just as the children and spouses of citizens are, so that they don't count against the green card caps. And the Relief Act would protect the aging out children who qualify for a green card based on a parent's immigrant petition. The Relief Act that I'm describing is not novel or controversial. It is based on a provision of the 2013 Comprehensive Immigration Reform Bill, which I helped to write with the so-called Gang of Eight. That included Senator McCain, Senator Graham, Senator Flake, as well as Senator Rubio on the Republican side, myself, Senator Schumer, Senator Menendez, and Senator Bennett on the Democratic side. We worked hard and passed that measure through the Senate Judiciary Committee and on the floor by a vote of 68 to 32. So what I am proposing is something I have proposed in the past, crafted, passed, and offered to the House of Representatives to help start to solve the immigration bill crisis which we currently have in this country. Unfortunately, the Republicans who controlled the House of Representatives when this measure came before them several years ago refused to even take up this measure and debate it. If they had, we wouldn't be here today. The green card backlog would not exist based on a provision which I offered with others in the comprehensive immigration reform. Unfortunately, some of my Republicans on the other side of the aisle are still unwilling to increase any number of immigrant visas. They want to keep the immigrant workers on a temporary basis where they and their family are at risk of losing their immigration status and being deported. The senior senator from Utah, Senator Lee, has introduced S-386, known as the Fairness for High-Skilled Immigrants Act, to address the green card backlog. I have a basic concern with that bill. It includes no additional green cards. Without any additional green cards, S-386 will not reduce the green card backlog. Without additional green cards, S-386 will not reduce the green card backlog. Don't take it from me. There are those who will disagree and say, oh, Durbin's wrong. He's just mistaken in saying that. Please go to the nonpartisan Congressional Research Service. Here's what they said about S-386, Senator Lee's legislation. Quote, S-386 would not reduce future backlogs compared to current law. So despite my concerns about Senator Lee's bill, I agreed to sit down and work in good faith with him to resolve our differences. Last December, we reached an agreement, I believed we did, on an amendment to the bill. The amendment doesn't address the core problem because it doesn't increase the number of green cards. As a result, it would not reduce the green card backlog, but there was an improvement in the amendment which we put together. I talked about it yesterday. Let me highlight two key provisions of our agreement. We protected the families that are stuck in this backlog waiting for a green card. Immigrant workers and immediate family members would be allowed to, quote, early file, close quote, for their green cards. That was a proposal that came to me from Senator Lee, and I thought was reasonable. These individuals would not receive their green cards early, but they would be able, while waiting, to switch jobs and travel without losing immigration status. I think that's reasonable. Early filing adds a critical protection that wasn't in S-386. Listen carefully. Our agreement prevents the children of immigrant workers from aging out of green card eligibility, so they will not face deportation while they are waiting for a green card. Our agreement also would crack down on the abuse of H-1B temporary work visas. Really, I think this is at the heart of the problems we're running into. There are corporate entities in India which have extraordinary power over the securing of these H-1B visas. The amendment we put together would allow legitimate use of H-1B visas, but here's what it would say. It would prohibit a company from hiring additional H-1B workers in the future if the company's workforce is more than 50 employees and more than 50% of those are temporary workers. The 50-50 rule is from a bipartisan H-1B reform bill that I authored with Senator Grassley. This provision also was included in the 2013 Comprehensive Immigration Reform Bill. Senator Lee has said publicly, and I quote, "This is a common sense reform to root out abuse." I think he's right. I know these companies despise this provision, and I think it's one of the reasons that we find ourselves with no common ground today. If this is included, they don't want anything to pass, and they're doing their best to stop it. The reality is that the top recipients of H-1B visas today are outsourcing companies that use loopholes in the law to exploit immigrant workers and offshore American jobs. In the most recent year for which data is available, 8 of the top 10 recipients of new H-1B visas were not individuals going to work for high-tech companies. They were these companies, outsourcing companies in India. Unfortunately, yesterday, Senator Lee objected to this proposal which we had put together. Instead, he offered a revised version that includes some changes that were requested by the Trump administration. Let me explain Senator Lee's changes, because I think they are basic and I believe they are a problem. First, he wants to remove a provision from our original agreement known as the Hold Harmless Clause. What it says is very simple. It assures immigrants already waiting in line for green cards that there's nothing that we will do that will in any way injure or delay their pursuit of a green card. They can't fall further behind in line. We hold them harmless from any change that we make. Why wouldn't we? Some of these people have waited for years. If you waited 10 years with 10 more to go, and we say, wait a minute, those 10 years don't count, it's 20 years altogether, that's not fair. The hold harmless provision basically says we're going to protect you wherever you stand in line. The second thing that Senator Lee wants to do is to delay for 3 years the effective date of the 50-50 rule to crack down on outsourcing companies. I don't know why we want to wait 3 years to do that. We don't have to. We shouldn't. Why on earth would we give these companies that are outsourcing American jobs and exploiting immigrant workers a free pass for an additional 3 years? Third, Senator Lee wanted to delay for years early filing for people who are stuck in the green card backlog. The object behind the early filing, and the reason why it was so appealing to me, was that it would protect the individuals applying as well as their families from the start. And now the senator has suggested that we delay this. That just means that many children will age out during that 3-year period of time and be subject to deportation. We shouldn't do that to these children and these families. Yesterday, I made a simple proposal to Senator Lee, which he said he hadn't seen personally, and that's why I've come back today, that while we continue to debate the best way to fix the green card backlog, let's make sure that no children of the affected families are harmed or deported. Just that simple. I offered a new bill, very simply stated, the Protect Children of Immigrant Workers Act. This brief 3-page bill would ensure that children do not age out while waiting for a green card. Imagine if you brought your family to the United States, worked on an H-1B visa, applied for a green card to stay in this country, and your children are waiting with you for the green card. You are paying for them to go to college because they don't qualify as American citizens for any type of federal financial aid. You're making great sacrifices for them, and then the day comes when they reach the age of 21 and they can be deported and your family divided. Why would we want to let that happen? This 3-page bill, the Protect the Children of Immigrant Workers Act, protects those children. It would not increase the number of green cards. It would not provide any special benefits. It would simply allow the children of immigrant workers to keep their place in line for a green card and be protected from deportation until they can get that card. Yesterday, Senator Lee said he'd not had a chance to review it, so I wanted to return to the floor today. I believe this is timely and important, and now he's had a chance to look at it. Senator Lee's original bill does not offer any protection for these children, which I think is a major humanitarian problem caused by the green card backlog. The early filing provision in my agreement with Senator Lee will immediately protect the kids in the backlog under the age of 21. However, if early filing is delayed, as Senator Lee now proposes, those kids would age out and lose their green card eligibility. I have met many of these young people. It breaks my heart to hear their story that they may be reaching a point where they've aged out and be deported. And that's why I wanted to offer this specific single provision. There is no reason these children should be punished for our broken immigration system. It's beyond their control, but it's not beyond our control to help them. I am now going to ask unanimous consent on the Protect Children of Immigrant Workers Act. Madam President, I ask unanimous consent the Judiciary Committee be discharged of S-4243, the Protect Children of Immigrant Workers Act, and the Senate proceed to its immediate consideration. Further, that the bill be considered read a third time and passed, and the motion to reconsider be considered made and laid upon the table with no intervening action or debate.
Is there objection?
Madam President.
Senator from Utah.
Reserving the right to object. For well over 8 months, my friend and distinguished colleague, the senior senator from Illinois, has been publicly blocking legislation protecting the children of immigrant workers, and now comes forward with something called the Protect Children of Immigrant Workers Act. He comes to the floor asking that we pass this bill by unanimous consent, a bill that, as he notes, was introduced just yesterday. Well, we must pass this now, he says, right now, because these children shouldn't have to suffer one more hour. With all due respect, Senator, they could have had relief months ago. They could still have relief today. I've taken the time since yesterday to review Senator Durbin's legislation, and I cannot support it. This legislation allows the children of H-1B workers to remain in the country for the 20 to 30 years that their parents have to wait. In the green card backlog, the same green card backlog that you, sir, are now decrying. When their parent dies, children of immigrant workers will not be immediately deported, but this prolonging of dependent status is helpful only if the parent lives and works in this country until his or her green card application is actually adjudicated. It does nothing for the child of an immigrant whose dead parent's green card application is ultimately denied because his or her job is no longer available. Nothing. To be honest, the 20 to 30 years is a short wait for most of the Indian nationals currently stuck in this awful, hellish green card backlog. In fact, it's a drop in the bucket. In 2020, the wait for an EB-2 green card is not, in fact, 20 to 30 years for an Indian national. What is it then? Is it 30? Is it 40? 50? 60? No, much longer than that. It's 195 years. So what this means is that someone from India entering the backlog today would have to wait 195 years to receive an EB-3 green card. Even if we give their children this limbo status, none of them will have a prayer of becoming a U.S. citizen. To put this in perspective, 195 years ago, John Quincy Adams had just recently been inaugurated as President of the United States. The legislation purports to allow aging out children to move to a student visa status, but it also fails to accomplish even this. Student visas require the applicant to have a residency in a foreign country, which obviously these children do not have. Perhaps these are merely drafting errors, but as such, they underscore my concerns about passing slapdash legislation just because it bears a title that compels us to believe that it will correct the most egregious problems and protect the most vulnerable populations. Even if we generously overlook these drafting errors, this legislation goes from sloppy to worse. Most egregiously, it'll increase the existing green card backlog. If we pass this legislation on its own, high-skilled workers from highly populated countries will have fewer and fewer green cards available to them, meaning they'll have to wait longer and longer for relief. In fact, by the time we stretch this out to 2030, the 195-year backlog I mentioned a moment ago would be extended out to 400 to 450 year of backlog. That's not fair. I can't imagine that's what the senator from Illinois wants. If we want to actually protect the children of immigrant workers, we need to end the inequities of the green card system. Real protection for the children is impossible unless we have a fair path forward for the parents. Now, I've worked for 9 years on a thoughtful solution to these problems in the Fairness for High-Skilled Immigrants Act. This compromise protects children, it protects widows and widowers, and it provides an equitable path forward for all of our high-skilled immigrants. And that's why I call on Senator Durbin to lift his hold on the Fairness for High-Skilled Immigrants Act and to provide relief to immigrant children and to their parents. As to the suggestion that the changes made to this legislation were bad, that they were a departure from what we agreed on, it's just not true. The implementation delay simply allows the USCIS the time to develop the adequate infrastructure to implement what we had proposed. The 50-50 rule change is 3 years is there to protect the H-1B visa holders who were already here. And the hold harmless provision, this was taken care of through the 3 to 9 year transition that now covers them. In any event, Madam President, this legislation, the one that Senator Durbin now tries to pass by unanimous consent, introduced for the first time yesterday, that I've now reviewed, is sloppy. It doesn't solve the problem, and it would make a lot of things worse. I therefore object.
Madam President.
Objection is heard.
Madam President.
Senator from Illinois.
Madam President, there is no question that there is a green card backlog for EB-2 visas. We issue 140,000 a year. We estimate that there are some 5 million seeking them. I want to increase the number of green cards. The senator from Utah opposes that. As a result, the bill that he introduced, according to analysis by the Congressional Research Service, this is not Durbin's language, Congressional Research Service, S-386, the Lee legislation, would not reduce future backlogs compared to current law. So when he talks about 195 years and John Quincy Adams or whatever his historical analogy was, he doesn't address that at all in S-386. And the problem, of course, is that he is bound to a position of his party that will not allow one additional new immigrant. None. I don't take that position. These men and women and their kids have been living in the United States, many of them for years, some of them for decades. Some of them are doctors in hospitals in my hometown. I trust them and I trust their kids. What I've asked him to do simply today is to join with me in protecting their children while we resolve the other issues. He refuses. He refused yesterday. He refuses again today. He calls my approach sloppy. Well, let's see the Lee alternative to it to protect the children. I'd like to see what he'd like to propose. Maybe it is language that's better, and maybe I can embrace it. But let's take care of that discrete part of this issue. Why would we leave these children, now aging into adults, at risk? That is just the wrong way to approach this. We can solve this problem, and we should. While we solve it, we should protect these children. It is within the ken of both Senator Lee and myself to sit down and through staff come up with that language. I believe we can. I just want to say I'm going to continue to offer this opportunity for Senator Lee to protect these children until we can sit down and in good faith resolve any differences that we have between us. But I've heard this case over and over again about the plight of these children. I am trying to address it. He continues to object. Madam President, I yield the floor.
Madam President.
Senator from Utah.
Madam President, we've got the opportunity right here to pass this right now. This bill fixes this problem. As to the suggestion that we can't do any of this without increasing the total number of green cards, this is a poison pill. My friend and colleague knows that it's a poison pill. In fact, we had that very discussion. Now, I don't ordinarily, in fact, I have a uniform policy against publicly talking about private conversations that we've had as colleagues. You've now brought it to the floor. We talked about this, and this was the basis upon which we reached a deal in your office in December. The point there was to understand that we can't pass something, certainly by unanimous consent, that increases the total number of employment-based green cards. It's not going to happen. So we're dealing here with that finite universe, and that was the basis of the deal that we reached in December. As to your suggestion that we can't do anything without increasing the total number of green cards, you know that's not on the table. No, that's not fair. What we want to do is make this process fair. Even if we only have a limited number of green cards to work with, which is the case, whether you like that political reality or not, it is the political reality. It is the factual understanding that you and I discussed and understood in December when we made that deal. The Lee alternative is the encapsulation of that. And that's why, Madam President, I ask unanimous consent that the Judiciary Committee be discharged from further consideration of H.R. 1044, and that the Senate proceed to its immediate consideration. Further, that the Lee amendment at the desk be agreed to, that the bill as amended be considered read a third time and passed, and that the motions to reconsider be considered made and laid upon the table.
Is there objection?
Reserving the right to object.
Senator from Illinois.
Just do the math. 140,000 EB-2 visas a year and 5 million people waiting. You think you can solve this without changing the number of green cards? You can't. You may address it from one angle or another. You may help some who are waiting as opposed to others. You only do that, give assistance to some at the expense of some other group. I understand your position, and I don't quarrel with the fact that you made it clear from the start that from your perspective and perhaps from your side of the aisle, there is just no appetite for increasing the number of green cards, even for these people who have been living and working here in the United States for years and sometimes decades, even for physicians from India and other countries who are literally risking their lives today on COVID-19 patients. You've told me there is no appetite for giving them additional green cards so that they can stay here on a permanent basis. I think that's unfair, and that is my position. You have made it clear, and I'm not saying otherwise, that you disagree with me. So what I've tried to do is to come in and say, at least during the pendency, while they're waiting for green cards, which could be decades unless the law is changed, let us at least protect their families. That's all that I basically said. You've come back and said, I want to put in a provision which takes out the hold harmless protection. I want to protect these people who are outsourcing companies in India that have captured the lion's share of these H-1B visas. And I want to make sure that those who are going to be protected have to wait 3 years before there's any protection. Why in the world would we do any of those things? But I'm willing to sit down and talk to you, but I'm not going to accept these at this point unless we can find starting point, protection for the children of these families. If you'll agree to that, I'm more than happy to discuss the other provisions again. But because the other provisions are now what you're offering, I object.
Madam President.
Objection is heard.
Madam President, the protection of the children is found in my proposal, which Senator Durbin has now objected to.
Senator from Utah is recognized.
Madam President, the protection for the children is now found in the proposal, in the amendment now at the desk, the one that was just objected to by my friend and colleague, the senator from Illinois. And I would ask my colleague, rhetorically or directly as he may choose, if in fact you were unwilling and remain unwilling to negotiate on any bill addressing this problem without increasing the total number of employment-based green cards, why on earth did you waste months of my time? Why did you leave me to believe in your office that you were open to such an agreement? That was, in fact, the premise upon which we proceeded. We spent months on that, and I worked in good faith. As I mentioned yesterday, it was against my better judgment that I agreed to announce with you on the Senate floor that we had reached an agreement because I knew that we had to work out a few kinks. But I proceeded based solely on the feasibility and our ability to implement that bill. That was the only change that we made. Now, if you want to make some adjustment to that, bring it forward. I'd love to consider it. But what you're now telling me is that the very premise upon which we proceeded in those negotiations and spent weeks and then months working on was false. That the whole premise, that is, that we could reach some sort of compromise, an actual compromise that wouldn't increase the total number of green cards available, was illusory. I find that disappointing.
Madam President, I think the gentleman, the senator rather, has addressed a question to me, I believe.
Rhetorically, or otherwise, you're welcome to answer.
Illinois.
I would like to, I know other members are waiting to speak, so I will try to be as concise and brief as possible. I understand your position. You don't want another green card. You believe members on your side of the aisle don't want to increase the number of green cards, period. I knew that going in. You made that abundantly clear. We can't solve the underlying problem without it, but we can make it better. And that's why we continue to talk and negotiate, and I hope we will continue to talk and negotiate. But for goodness sakes, the starting point ought to be the protection of these children. Cannot we agree that we will protect the children and then proceed to continue the negotiations on the premise that you can't accept one more green card? I can, you can't, but we will try to improve the system with that premise accepted. But at the starting point, for goodness sakes, let's protect the children while we negotiate and debate, and hopefully we can do it on a timely basis. That's my response. I'm willing to continue to work, and I understand you cannot issue another green card. The math never works with 5 million people working and 140,000 green cards a year. It never is going to work, but I'm willing to try to make the system better, understanding that I would increase the number of green cards and you would not.
Madam President,
Senator from Utah.
I'm always happy to discuss any counter proposal. If you want to make one, I'd love to see it. It is not fair to say that I don't care about those kids because I'm unwilling to create additional green card slots. If you want to protect these children, pass this bill, pass it today, pass it this very moment.